the Senate Judiciary Committee will come to order. Thank you all for being here today. The first item we have on today's agenda is a hearing on House Bill 2299, allowing a search warrant to be executed within 10 days from the date of issuance. We will ask for the bill brief from the reviser, Mr. Thompson. Thank you.
Thank you, Madam Chair, and good morning, committee. House Bill 2299 comes to you as amended by the House Committee of the Whole. I had the vote noted somewhere, but I apparently didn't bring that up with me. So I'll get you that here in just a moment. The bill indeed deals with the time within which a search warrant may be executed, and the current law there in the bill is KSA 22-2506, and it requires a search warrant to be executed within 96 hours from the time of issuance. The bill as introduced would have required a search warrant to be executed within 10 days from the date of issuance, and then as amended by the House Committee of the Whole, the bill requires it to be executed within 240 hours from the time of issuance. So changed from 10 days to 240 hours, and the current time is 96 hours. And I'll be happy to answer any questions.
Thank you. Committee, questions for the reviser? Senator Thompson.
Real quick, well, maybe I'll ask for the proponents. Never mind. Thank you.
Thank you. Committee, other questions for the reviser? Seeing none, then we will invite our first proponent conferee, Representative John Ressman, District 121 in the Kansas State Legislature. Please introduce yourself and welcome Representative to committee.
Thank you, Madam Chair. I'm Representative John Ressman from District 121, and the House vote was 119-2 on this bill. Madam Chair and members of the committee, I want to thank you for this opportunity to testify on House Bill 2299. The intent of the bill is to extend the time in which a search warrant can be served from 96 hours to 10 days or 240 hours. This is just as much about the time as it is about safety, and to serve a search warrant at the most safest time as a result of some of the things that have happened around the country. Currently, there are 26 states that allow 10 days, including every state that touches Kansas except for Colorado, which allows for 14 days. The intent is to ensure the safety of everyone, both law enforcement and the public. During my career in law enforcement, which is 30 years with the Johnson County Sheriff's Office, I was able to see firsthand how to ensure the search warrant was served safely over a 10-day period. As a member of the Metro Squad investigating a homicide in Missouri, it became necessary to serve a search warrant. Being a law enforcement officer from the state of Kansas, I naturally assumed it was 96 hours in Missouri and later found out it was 10 days. What made this kind of unique was it was a homicide and home invasion in which the homeowner was killed with a shotgun. We had located the shotgun and the suspect in a residence, and I wanted to serve the search warrant within the 96-hour period because I thought that's what it was, and come to find out it was 10 days. But when you have a suspect that's already committed a homicide, is willing to use a shotgun, you want to make sure that you serve that search warrant at the safest time possible. And if it takes longer than the 96 hours, I think that we should do that to ensure everybody's safety. One of the problems, with any problem or task, the more time you have to solve that problem, the more successful is an outcome. And I can give you a prime example. This is right after turnaround. There's a lot of work that needs to be done. We have a limited amount of time, and it would be nice if we had extra time to pass bills. But unfortunately, we're under a time limit, and it would hold true as a search warrant. The greater the time, the greater chances of safety. Serving a search warrant has always been always has been unpredictable and dangerous. I'm sure you read in the newspapers about some of the fatalities that have occurred throughout the country as a result of search warrants being served. There have been many times I've been personally involved in literally probably hundreds of search warrants, and some of them have required some of the people that have medical attention as a result of our entry into the homes. Thankfully, none have ever resulted in a death. I just wanted to talk about two instances that occurred. We're going to serve a search warrant in Overland Park, and we knocked on the door. The door opened. People saw that it was the law enforcement, They immediately shut the door. We had to force entry. And once we got inside, there was a physical altercation that also involved an elderly gentleman who had bypass surgery and was on oxygen. And if that doesn't scare you about having to execute a search warrant while you're fighting someone who had just had a serious operation, and we had to have medic come and assess him. The second one I wanted to talk about real quick was the exact opposite. We knocked on the door opened, and we were rushed by a group of people from inside the house. We were forced out to the front lawn. The neighbors were calling 911. We were calling for assistance. Within minutes, we had probably 20 or 25 officers show up. And what happens is that when those officers show up, they have no idea why they're responding, other than they know officers are asking for assistance. It resulted in people having been pepper sprayed. Medic had to be called for them to be assessed, and several people went to jail that probably didn't have to go, but that was their actions. Prior to a search warrant, we always tried to identify people living or staying in the area in which we intended to serve a search warrant. We often conducted drive-bys, conducted surveillance to learn everything we could about the people inside that residence. However, this takes time. A search warrant, from the minute it's signed by the judge until you complete your search, which you have to also encompass search time, which could take hours or days. You have to complete it within 96 hours. And sometimes you're under a really tight time restraint as far as getting the search warrant served. I would hope that with passage of this bill, it would make it much safer for officers and the public. And should there be children in the residence, to allow time for them to go to school or leave, which adds to the time that the search warrant has to be served. I would hope that this committee would pass this out and get it to the Senate floor so we can ensure the safety of law enforcement and the public. Thank you, and I'll stand for questions.
Thank you, committee, so that the representative can get to the House floor, which I think session is today at 11 o'clock. If we could ask our questions of the representative at this time, that would help him be timely on the House floor. Are there any questions for the representative? Senator Gossage.
Thank you, Representative, for being here. So my understanding is, I guess this is totally new to me. If you needed to do a search warrant, you have to do it currently within 96 hours of what?
From the time the judge signs the search warrant. When you appear in front of the judge, he'll read the affidavit, look at the search warrant, and then he'll sign it and date it with the time. And then you have 96 hours from that time. And that, like I said, that includes the search time itself, which you have to think about the area or exactly what you're looking for. The smaller the item, the longer it takes to try and find it. So.
And I would think that it would be advantageous to do it as quickly as possible, if that were possible. Right.
Correct. And this is not intended to serve the search warrant on day 7, 8, or 9. This is just in case you run up against 96 hours, that you can take an extra day or two or whatever it takes to ensure the safety.
Thank you. Thank you, Madam Chair.
Senator Thompson.
Thank you, Representative, for being here. Does this also play into picking the optimal time to go when somebody who is dangerous may not be at the home? Or I just wondering about that.
I can tell you, one of the things that we tried to do was that if there was a particular person we were looking for, we would try to wait for that person to leave the residence, conduct a traffic stop, and then bring them back to the residence. We were going to search it. The chances of something happening with them present with us, it goes down dramatically. But you have to wait, and that sometimes runs into problems.
Thank you. Thank you, Madam Chair.
Other questions? Seeing none, then thank you very much for your testimony today, Representative. It's good to see you.
Thank you.
Thank you. Next, we will hear from Ed Klump, Legislative Liaison, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. I think I've said that so often in committee, I could almost say it as well as you, Mr. Klump, but probably not. But
about as fast, but I'm not going to compete with you. So those are the associations I'm here to represent. My name is Ed Klump. Madam Chair, committee members, thank you for having this hearing today. This has been an important bill for us, addressing some of the issues surrounding search warrants in Kansas that have come up over the last few years at a national level. And we think this is a start to address those. We would just point out that we looked at all the border states around us, and all of them except Colorado use 10 days and have for years. Colorado uses 14 days. All of the 10th Circuit states use 10 days, except for Colorado. They use 14. As we did our research, and I don't have the robust ability to look at other states' laws like some people in the room do, but we found 19 other states we looked at, and we only found one other states in those 19. We understand there's probably 3 states, including Kansas, that are under 10 days. So 10 days is the most common that's used. There's some that use quite a bit more than that, but we think 10 days is reasonable, and that's what we're advocating for. So these longer periods to execute these search warrants, they assist us in many ways. It gives us more time to plan when the appropriate time is to serve that warrant. And sometimes that's because of the volatility of it. Sometimes, like in drug raids, we will get a search warrant based on a small quantity of drugs, knowing that a large quantity is supposed to arrive. And sometimes that schedule gets off. And so this would allow us to further our information and make sure that that larger quantity is there before we serve those warrants. I can give you an example of a case we had years ago that did not end well, that nobody was hurt, but it got out of whack because we had a search warrant for a nightclub that was selling drugs out of the place. And there was supposed to be 3 shipments come in this night, which is why we wanted to do that. For some reason, they got the search warrant early, and that was the end of the time period was that night to serve this warrant. And we got information that one of the shipments arrived, but the other 2 had not. And so the decision was made, not by me, that we would go ahead and serve that search warrant and address the situation. And that was based generally because we didn't have any more time to do. Otherwise, we had information that shipment would probably come in on the next night. So that's an example in a non-violent situation. But we think this does have a lot to do with safety. Somebody asked about the time, to adjust when it's more appropriate and less risk. It's absolutely one of the things that plays into this. We do not want to do high-risk warrant entries if we can possibly avoid it. They're dangerous for us. They're dangerous for everybody. And this will give us that flexibility. Madam Chair, I'll stand for questions.
Thank you. We'll hold the rest of the questions till we've heard from all the proponent conferees. Next, we will invite Mr. Greg Smith, Special Deputy Sheriff for Government, Veteran, and Crime Victim Affairs, Johnson County Sheriff's Office. Please introduce yourself and welcome back to committee.
Thank you, Madam Chair. I am Greg Smith. I'm Special Deputy for Government Affairs for Johnson County Sheriff's Office. We too advocate for this bill and for the 10-day period for all of the reasons that you've already heard, and I won't go back into those. I learned a long time ago when I was in the legislature, if somebody's already said what you said, what you wanted to say, there's no sense in repeating it. But I would want to point out, I know that there's some concern with a 10-day period. One thing that I've heard in talking with some members of the committee and other legislators is that there's worry that perhaps the information would go stale and not be valid if we had a longer period of time. There's well-established federal case law that prevents us from executing a warrant if we know the information has gone stale. So I think the protections are already in place should it come to that. And again, for all the reasons you've heard, we advocate for the 10 days. Happy to stand for questions.
Thank you. We also have proponent written only testimony in your committee folder from John Goodyear, General Counsel, League of Kansas Municipalities. Are there any other proponent conferees in the committee meeting room or online? Seeing none, then we'll go ahead and open it up for questions for our proponent conferees. Are there any questions? I think one of my questions was addressed in that the reason warrants are required in these situations is the Fourth Amendment requires that and states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So as I look at the Fourth Amendment and look at what's proposed here in this bill, want to ensure that when we extend the time period to what the bill proposes, 240 hours, that we are cognizant of the Fourth Amendment requirements and that the probable cause that led to the court issuing the warrant is still going to be the probable cause when the warrant is then served within the 10 days. So I think Mr. Smith spoke to that briefly. I think Mr. Klump did, I'm sorry. But could one of the conferees address that as well, that we're making sure that the probable cause as it existed when the warrant was issued is still valid probable cause when it's 238 hours later as proposed by the bill. Again, to protect the rights of citizens as well from unreasonable searches and seizures. So if one of the proponents could address that quickly.
And Greg Smith with the Johnson County Sheriff's Office. Madam Chair, you're exactly correct. The concern that the probable cause that existed at the time the warrant was issued may not be there at the time that the warrant is served, like as I spoke about and Mr. Klump spoke about. There's well-established case law that prevents the execution of that warrant should the information become stale. This is more of a safety factor than anything else, as you heard Representative Resman talk about, and some of the situations that he's been involved in. I could do the same thing, but I don't think you want to hear me stand up here and tell stories about, glory days. So that pretty much sums it up.
Well, and our law enforcement community is well versed in, though you may have a search warrant, if you know that the probable cause has changed, you would then not execute that search warrant. Is that my understanding of our current, based on current case law and how we operate to serve the warrants, that it's in compliance with the Fourth Amendment?
Madam Chair, that's absolutely correct. It's one of the things that we're trained on, probably more even than lawyers are, is Fourth Amendment. So,
well, you want to, as law enforcement, make sure if you're serving or enforcing a warrant that it's going to be upheld and it's going to be properly executed, and you are looking at those facts and circumstances to ensure that that is happening when those warrants are executed or served. Is that right?
That's absolutely true. And I can cite instances that I've been involved with where we discovered that the information we had become stale, that the situation had changed, and we didn't execute the warrant.
And then you went and got a new warrant and started at the time, the 96 hours again, so that we could be ensured that there was proper probable cause for the warrant and then for the execution of the warrant.
Correct.
Thank you. Committee, other questions for the proponents? Seeing none then, are there any neutral or opponent conferees in the committee meeting room or online? Seeing none then, thank you very much for the testimony today and for appearing in person and in committee, and for Representative Resman for waiting in committee for any questions, and we still get you then to the House floor on time, I think. Thank you. With that then, committee, we will close the hearing on House Bill 2299 and open the hearing on House Bill 2515, creating a mechanism to seek relief from the Kansas Offender Registration Act requirements for drug offenders and allowing expungement of offenses when such relief is granted. And with that, then we will ask for the bill brief from the reviser, Mr. Thompson.
Thank you again, Madam Chair. So House Bill 2515 comes to you from the House Committee on Corrections and Juvenile Justice, requested there by the chairperson, Representative Owens. It passed the House 120-1. So the bill does create a mechanism for relief from Offender Registration Act requirements for drug offenders, and also briefly gets into the Expungement Statute to allow expungement of offenses when that relief is granted. I'll focus, and the bill brief focuses on Section 2 of the bill, which is the offender registration provision. The current law provides that essentially you're on the registry for some period of time that's determined by your offense. It can be 5 years, it can be 15 years, it can be a lifetime, depending on your offense. For drug offenders, it's and they can, the proponents can correct me if I'm wrong. For drug offenders, some of them are in the 15-year category. So that's the reason for this exit mechanism that would allow that at an earlier period after 5 years, essentially. So the bill provides that except for certain offenders required to register because of their out-of-state convictions or out-of-state adjudications, that if you're a drug offender required to register under our Offender Registration Act, and you file a verified petition of relief with certain requirements that are met, and you've waited 5 years from your date of parole, discharge, or release, or 5 years from, if you're not confined, from the date of your conviction or adjudication, then you're eligible for this potential option of early release from the registration requirements. There are a number of provisions in the bill about what is required in the verified petition. It's similar to a petition for expungement. It has all the information about your current name, your former name, your date of birth, the offense that required registration, all the information the court would need to figure out who they're dealing with and what offense they're dealing with. There are also provisions in the bill about the Judicial Council developing a form that would be used under this section, just like they do for other petitions that you can file to help folks do this sort of on their own. And then there are provisions requiring the county or district attorney in the matter to notify the victim if they're alive, or the victim's family if the victim is deceased. So there is some victim notification provision as well. The court is given also the option of requiring a risk assessment for any offender who is petitioning for relief. It's not required, but it is an option for the court. The court is then required to order relief from registration if the offender shows by clear and convincing evidence, so a higher burden than just the normal burden, clear and convincing evidence, that they meet 3 requirements. First, that the offender has not been convicted or adjudicated of a new felony within the 5 years immediately preceding the petition, and they don't have any currently pending proceedings against them for a felony. Second, that the offender's circumstances, behavior, and treatment history demonstrate that the offender is sufficiently rehabilitated. And third, that registration of the offender is no longer necessary to promote public safety. So if the offender can prove those 3 things through their petition and the hearing by clear and convincing evidence, and if they can do a risk assessment if that's required by the court, and all the other procedures were followed, the court will grant this petition. The offender is then removed from the registry, and the offender is no longer required to comply with the registration requirements. And then within 14 days of that decision, the court notifies the Kansas Bureau of Investigation. The KBI, of course, maintains the offender registry, and they maintain the internet website that we all can look at to find out who's an offender in our state. And they would be then charged with removing that person from the website so that they're no longer listed as an offender. If the court finds that the burden was not met and they deny the petition, the offender is then not allowed to file another petition for 3 years unless the court orders a shorter time. So you can't just keep filing it over and over again without court permission. You'd have to wait at least 3 years unless the court allows you. That pretty much covers Section 2. That's the main mechanism. And I'll briefly mention Section 1 is our Expungement Statute. You're probably getting familiar with that one since we deal with it fairly regularly. There's a current subsection F that just says an offender who's required to register under our Offender Registration Act shall not be granted expungement of any conviction while the offender is required to register. So in this case, I'm a drug offender. I have a drug conviction. While I'm required to register for that conviction, I cannot expunge any conviction in my record. So I could not expunge even an unrelated theft conviction or a DUI conviction, anything. All of my criminal history is locked in. I can't expunge anything. The change here would say that this exception applies. If you get your drug offender registry requirement removed, you're then allowed to file for expungement of that offense and other offenses that you may have in your record, if it's otherwise allowed. So that's the reason the expungement provision is in there. I think that covers it, and I'll be happy to answer any questions.
Thank you. Committee questions for the reviser? Seeing none, then we will invite our first proponent conferee via WebEx, Jennifer Roth, Legislative Committee Co-Chair, Kansas Association of Criminal Defense Lawyers. Please introduce yourself and welcome to committee.
Thank you. My name is Jennifer Roth. I'm hoping you can all hear me. I'm not very good at WebEx. I'd be there in person, except for I'm in another state. But my name is Jennifer Roth, and I am here today on behalf of the Kansas Association of Criminal Defense Lawyers. I come to have information and sort of, I guess I'd say, expertise about the registry because I've been a state public defender for almost 24 years, and I've been testifying about core at the legislature for 18 sessions. So I encourage folks to, if you have any questions today, or if you want to reach out with any questions later, my email is on my testimony. But we are here in support of this early removal possibility that 2515 presents. I just want to give a little bit of background as to why we have this bill. And the reason is because we have a drug registry. We've had one since 2007. People that are convicted of any possession with intent to sell or distribution or manufacturing or possession of precursors. And those latter crimes, I've heard the Wichita Sheriff tell us, we don't see as much anymore, but there are hundreds of people that are up to thousands who are convicted every year of a distribution offense. And so it doesn't matter the quantity, doesn't include marijuana, but it doesn't matter the quantity, doesn't matter if you traded it to your friend or if you're a user, you go on the drug registry because your crime of conviction is covered. No other state has anything like this that I have found. We are basically an outlier for now 15 years. So, and there's no early release, as Mr. Thompson told you, and he did an excellent job explaining what the current state of the law is now. And so right now, it doesn't matter how much you've turned your life around, how much you've complied with everything society and your probation officer and everybody else wants you to do, you have absolutely no chance of being released from the registry early. And right now, based on a law that passed in 2011, people, the minimum time they spend on that registry is 15 years. And if you have 2 qualifying convictions, so maybe you got convicted, twice of possession with intent to sell, you register for life. So there are lifetime registrants for drug convictions. But in the House, I wish that I had been able to get a hold of this proponent from the House side, but you could see his testimony on the House side. But there was a man named Danny Kravitz who testified. He is a drug registrant, and he's done every single thing asked of him. And the judge and the prosecutor even said, hey, we'd let you off this registry if the law allowed us, but it doesn't. It is for people who have done all the things we've asked of them, have the belief we have in people's ability to change and redemption. This would be able to fulfill that further by giving them a chance to get off of the registry. And I did want to tell you that every time the law changes, at this point anyway, it's applied retroactively. So for example, if a person got convicted of a qualifying drug offense in 2010, they were told maybe that you had to register for 10 years and this and that. And then when the law changed, all of those changes apply retroactively to them because our courts have told us that somehow registration isn't punishment. So this bill would provide that exit mechanism. And another thing I wanted to just make clear is that we used to have an exit mechanism in our registry law from 1993 to 2000 when it covered, 1993 to 2000, that's what I mean, when it covered only people who had been convicted of sex offenses. There was an early release mechanism that was even, I think, easier to try and get than the one that's proposed here. And then for another 9 years after that, that mechanism was available to people who were on the registry because of some sort of retroactive application. And then that got taken away in 2011. So we're actually asking for something to be put back into the law that had been there before. Sorry, I'm just looking at my notes here. Oh, another thing is that, speaking of legislative changes, so in 2013, the legislature changed the definition of who is a drug offender, and it made it so that it was people that were convicted only after July 1 of 2007. And what that meant is that a bunch of people who had had it applied retroactively to them, and I don't know that number, but it's got to be in the hundreds, if not more, those people were no longer required to register, and they were removed from the registry. And I've never heard anybody say that the sky fell. So we actually have experience with removing hundreds of people from the drug registry and not seeing a negative consequence to that. that anybody's ever pointed out to me. So I just wanted to appear in person, even though I'm sorry I'm not there in real life. But I wanted to appear in person because I do have a lot of background information about how we came to be where we are today, and also the policy sort of decisions and the research that we looked into. And I say we because this exit mechanism, even though this bill is not a judicial council bill, this exit mechanism is word for word out of a recommendation that a judicial council subcommittee made. And so we did a lot of talking, a lot of researching, things like that to arrive at this exit mechanism. And so I do, on behalf of KCDL, encourage this committee to pass this out and take this first step. But also we hope, I very much hope, that this committee and the rest of the legislature considers making other steps additionally in the future. So I think that's all I wanted to say today, but I'm happy to stand for questions whenever's the appropriate time.
Thank you for that, and we will hold questions until we've heard from all the proponent conferees. Committee, you also have in your committee folder proponent written only testimony from Patrick Armstrong, project manager, the Council of State Governments Justice Center. And I believe we also have proponent conferee on WebEx, Eileen Berquist, community engagement manager, ACLU of Kansas, who is not online at this time. So we will then ask, are there any other proponent conferees in the committee meeting room or online? Seeing none, then committee, any questions for our proponent conferee? Not seeing any, then we will ask, are there any neutral or opponent conferees in the committee meeting room or online? Seeing none, then Ms. Roth, thank you for your testimony today and for appearing via WebEx. Though your preference was to be in person, you're busy elsewhere. So thank you for your time and your testimony. And with that, then we will close the hearing on House Bill 2515. We will now turn to possible final action on bills previously heard, and we will be looking at House Bill 2517, which we heard yesterday, and 2517, excuse me, is transferring the responsibility to certified drug abuse treatment providers that participate in the Certified Drug Abuse Treatment Program from the Department of Corrections to the Kansas Sentencing Commission. And if we'll stand at ease for just a moment before we get the bill brief. Thank you, committee. With that, then we will ask for a bill brief from the reviser.
Thank you, Madam Chair. As you mentioned, House Bill 25, Jason Thompson with the Revisor's Office. As you mentioned, House Bill 2517 is the bill you heard yesterday, brought by Scott Schultz on behalf of the Kansas Sentencing Commission. It does transfer the responsibility over what you all call the Senate Bill 123 Drug Treatment Program. The certification of the providers for that program, it transfers the responsibility for that from the Department of Corrections to the Sentencing Commission. And I guess the only other thing you usually ask for is the vote in the House was 120-0.
Thank you. Committee, I do have what I will call a technical amendment to offer that I'll ask be distributed, and it's changing the date of the enactment clause there in section 5 to change it from publication in the statute book to the Kansas Register. And that's so we can get it to conference committee and take a look at it there. So do we have a second for the amendment? We do, from Senator Haley. Thank you. Committee, you have seen the amendment. You have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, we are back on the bill. Is there a motion regarding the bill? Senator Haley.
Thank you, Madam Chair. I would move that we report 2517 as amended, favorable for passage.
Thank you. Committee, is there a second? Senator Thompson, thank you. Committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, we do have House Bill 2377 regarding DUI that has been referred back to Judiciary Committee. We are scheduled to hear House Bill 533 tomorrow, and 533 increases the period of time that a person is disqualified from driving a commercial motor vehicle for certain violations, and prohibiting prosecuting attorneys from concealing certain traffic violations from the CDLIS driver report for holders of commercial driver's licenses and commercial learner's permits. The bills are pretty substantially related, so wanted to work House Bill 2377 after we heard Senate Bill 533. So that's what we will be looking at tomorrow, and possible final action on a couple of other bills that we have heard recently as well. So want to thank the committee for your attention today and your work. And with that, then, we are adjourned. Thank you.